Okay, this is the feedback to assignment legal 1. I will give you the correct answers and I'll make some additional remarks. Let's go to the case. This is the case. There is much demand for new houses in Municipality A. A is a mid-sized village in the center of the Netherlands, and the municipality wants the new houses to be located in a new residential area. First question. Project developer Q is willing to develop a new residential area in A. However, Q does not own any land in the area that needs to be developed. The municipality A2 has no ownership of land in the area. All land is owned by farmers. Question: how can the problem of Q not owning any land be solved? Give an outline of the different possibilities. Well, this question was answered rather well by the students. I will show you the different ways in which Q can be helped. The different ways after which Q can become owner of the land. I have 2 slides for this answer. There are several ways in which the problem can be solved for Q. First is that Q buys land from the farmers himself. Of course, this is based on voluntariness of the farmers. If the farmers are not willing to cooperate, this will not work. 2. The municipality buys land from the farmers and sells the land to Q. There might be a reason that the farmers are not willing to sell the land to Q directly and are willing to sell the land to the municipality. Well, in that case, the municipality buys the land and then sells it to Q. Section 5.4 of book Planning and Development Law in the Netherlands explains that in the Netherlands, as in many other countries, but not all countries, municipalities can buy land under private law, which means buy land just like any other person or institution can buy land. 3. Municipality A expropriates the land from the farmers if they are not willing to sell it to Q or A. This, of course, is a special power of municipalities and other bodies of the state. The power to expropriate. After becoming the new owner of the land, A can sell the land to Q. See sections 2.5 regarding expropriation and section 5.7.7 in the book regarding sale of real estate by municipalities. There are yet 2 other ways in which Q can become owner. 4. Municipality A establishes pre-emption rights in the area that has to be developed. Now, farmers who want to sell the land must offer it to the municipality. If the municipality becomes owner, they can sell the land to Q. Section 2.4 in the book explains the phenomenon of pre-emption rights. Pre-emption rights are seen worldwide. 5. And this was mentioned by some students, but only a selection, and it relates to public-private partnership. Municipality A and property developer Q decide to work together for the development of the new residential area. For this purpose, they set up a land development company, in fact a joint venture. Both parties try to buy land from the farmers, and the municipality may, in addition to buying land, exercise its right to expropriate. Subsequently, both parties transfer their property to the joint venture. Actually, in return for transferring the property to the joint venture, A and Q both will receive shares in the joint venture company. A and Q develop plans for the new residential area together in the framework of the development company. Section 5.7.7 explains PPPs in urban area development. Let's move to question number 2. Suppose that eventually Q has enough land in ownership to develop the residential area. Next, a conflict rises between Q and municipality A regarding how many houses should be built and the contents of the urban design. Project developer Q is of the opinion that he has control over these matters because he does the investment. Municipality A, however, states that the number of houses and the urban design fall within the general interest, and thus the municipality has control over the number of houses and the urban design. Question: from a legal viewpoint, who has the authority or power or control over the number of houses and the urban design? Motivate your answer. Almost all students were correct in answering this question. The correct answer is that the municipality ultimately has the authority, the power, the control to decide the number of houses and the urban design. This is because the municipality has the power to adopt the local land use plan for the area that is to be developed. And in short, the land use plan determines what can be built, where it can be built, and which regulations, such as building heights, apply. Section 3.5 and 4.7 explain this. This includes the number of houses and the urban design. Section 4.7.1 explains that. So, ultimately, it will be the municipality. Most students did not refer to the environmental permit to build in answering question 2. However, if you did, it would have given you extra points. The property developer needs an environmental permit to build the houses, and the application for the permit will be tested against the land use plan, explains in section 3.2.5, which essentially means that if the plans of the developer do not meet the requirements of the land use plan, the permit will be refused. So the permit is an important instrument for the municipality and can be seen as an instrument of power. It gives the municipality power because every house will need a building permit, and the permit is tested against the land use plan, amongst other things. And of course, the land use plan lies within the authority of the local authorities, of the local government. How does it work in practice? How is it in practice regulated how many houses can be built? Well, usually municipalities define the number of houses to be built as follows. They will indicate a minimum or a maximum number of houses per hectare. Or, alternatively, they may indicate a maximum total of houses or a minimum total of houses to be developed in the area. But it could be that the municipality exactly states the number of houses to be built in the area. Some students answered that it's not possible, but it is possible. If students answered the following, it would have been correct. If students answered, if the number of houses is not specified in the land use plan, Q has authority on this aspect, taking the urban design as included in the land use plan in account. That answer is correct. Also correct is the following answer. The project developer has control over the number of houses and urban design as long as it is according to the regulations of the land use plan in force. That is correct as well. What is also correct? Another answer I found. Public and private parties A and Q depend on each other. A needs investments from Q, and Q needs a permit from A and has to satisfy, therefore, the land use plan. That answer is correct as well because it refers to the permit and the land use plan. Let's move to question number 3. Municipality A would like the new residential area to be easily accessible by national train. However, currently there is no national railway to the village. Question A. who has the power to take a decision about the construction of a new national railway to A? Most students correctly answered that this is the Minister of Infrastructure and the Environment. That's explained in sections 6.3 and 6.4. To be specific, the minister takes the track decision. Quite some students answered the state. In itself, the state is correct, but this answer was given fewer points because the state is a little bit too vague. Some students answered, it is directed by the Minister of Infrastructure, but lower governments have influence. That is correct as well, but also is a little bit too vague. Furthermore, some students answered referring to the 3 domains of power that are explained in chapter 6 of the book. And the 3 domains of power are administration, politics and justice. This too is a little bit too vague because in essence it is the minister who has the power to take the decision to start procedures and who also has the decision to end procedures. So in that way the minister should be considered to be the most powerful person in procedures. Question B. Does the municipality of A has much influence or little influence on the decision to construct a new national railway? Motivate your answer. Well, municipalities such as A do have legally ensured possibilities to influence decision making, explained in section 6.3. So that would have given you a number of points. In this case, the new railway most likely will hold 2 railway tracks. Almost no students indicated that the full procedure would apply. The full procedure holds a number of moments on which the municipality A will be consulted by the minister, actually of course the minister's civil servants, and B has the chance to submit views to the minister regarding draft intermediate decisions by the minister. Those are 2 different things. To be consulted is being actively involved in the decision making. So the minister asks upfront the municipality its opinion on certain aspects, and that is different from the opportunity to submit views, because views is submitting views is reacting to draft decisions by the minister and usually has the form of an objection. So making a distinction between being consulted and submitting views would be the best answer. Furthermore, apart from being consulted and submitting views, the municipality may influence legislators in parliament if the preferred decision of the minister is discussed in the second chamber of parliament. So the municipality has the power to put pressure on politicians in second chamber. Quite some students referred to this possibility, and that's good. In the end, it remains a personal decision to qualify both possibilities to influence decision making as. So both possibilities, being consulted and submitting views, as much of little influence. If well motivated, both answers, much or little, are correct. Most of the students answered that the power of the municipality is relatively small. And actually, I agree with that. Finally, question C. Suppose that eventually, by the body of question A, so the minister, the decision is taken to not construct a new national railway to A. Can the municipality take legal action against this decision? Explain. No, the municipality cannot take legal action against the minister's decision to not construct a new railway. This is laid down in the Crisis and Recovery Act, Article 1.4. This article expresses the legislator's opinion that branches of government, in this case municipality minister, should not fight against each other in court, but should settle their disputes through negotiations. Explained in section 6.4. And of course this also serves speeding up the decision-making process. So the municipality has no power to take legal action. However, NGOs like environmental special interest organizations or citizens do have the power to appeal against the minister's decision. So it is not that the decision cannot be contested in court. It is only that the municipalities do not have the power to appeal. And actually that is where this question refers to, because taking legal action in this phase of decision making means being able to appeal. So students who answered that in itself correct answers but do not relate to appealing were not giving points for this question. Okay, this is the discussion of the correct answers. As said, most students have done really well, and I'm satisfied with that.